I call the honourable member for Wannon.
Thanks, Mr Deputy Chair, and can I congratulate the member for Higgins on her first-class speech and on her commendation to the House to pass this important bill, which is another part of our suite of measures which will help us keep our citizens safe. And that is why the government has now put through the parliament in the last 6 months 3 important pieces of legislation, because the government is determined to keep our citizens safe. As the Prime Minister has said, it is the #1 duty of any government, and it is a duty that this government in particular, given the heightened security threat that we have seen as a result of Australians travelling to both Iraq and Syria and returning, the threat that they are presenting to our nation. So it is very important, Mr Deputy Speaker, that we continue to do everything we can to keep our country safe. And the government is about to bring another important piece of legislation to the vote, which will occur early next year, in the first quarter of next year, which will be around the retention of metadata, and that will be the 4th component of the measures that the government is putting in place. Let me turn to this piece of legislation, the Counter-Terrorism Legislation Amendment Bill No. 1, 2014. The Parliamentary Joint Committee on Intelligence and Security looked at this piece of legislation, like it has the previous 2 pieces of legislation, very carefully. And in our report we came up with 16 important recommendations. And, Mr Deputy Chair, I might just step through a few of these, because I think it's important to inform the House of how the committee deliberated on this piece of legislation, and then, in a bipartisan report, recommended that the legislation be passed by the parliament with this list of recommendations. And I might just pause before I look at some of the key aspects and just pick up on some of the criticisms that have been levelled at the process, and by one particular individual in this place who referred to the committee as some type of club. And can I say that I find those sorts of references to the committee ill-informed, ill-advised, and obviously that's not the approach that serious members of this House would take. The committee, every member is appointed by the Prime Minister, and I can tell you everyone who is on that committee takes their role incredibly seriously. And it is why, with the first piece of legislation, the National Security Legislation Bill, the committee put forward 17 recommendations, all of which were adopted by the government. In the second piece of legislation, the Foreign Fighters Bill, 37 recommendations were put forward by the committee, all of which were accepted by the government. And obviously, with this bill before us here, another 16 recommendations were put to the government, all of which were accepted. And if you look at those recommendations, take the Foreign Fighters Bill for instance, there was sunset clauses put in on some aspects of that legislation. There were review process for both the National Security Legislation, Independent National Security Legislation Monitor, and for the committee itself. Review processes put in. Now, these were not the decisions taken by some sort of club. This was a committee with each individual on it seriously looking at this legislation and deciding what they thought was best when it came to how the parliament should consider this. So any idea of some sort of club, I think, is ill-informed and ill-advised, and I would hope that we would see a better and more informed debate when it comes from the Greens in the future, when we are considering very important legislation for this nation. So, with that little that little side matter dealt with, and it is unfortunate that those types of things have to be dealt with, because it would be much better if we were here debating the substance of this bill rather than people trying to have cheap political shots on national security. So when it comes to the bill itself, what did the committee recommend and why? Well, Schedule 1, what the committee recommends is the government finalise, to start with, the appointment of the Independent National Security Legislation Monitor. Obviously, this is an important step and something which the committee has urged the government to do as an active priority, because what we would also then like the INSLM to do is consider whether additional safeguards recommended in the 2013 Council of Australian Governments review of counter-terrorism legislation should be looked at, and that consideration also be given to whether special advocates need to be considered, and also that all this take place given new developments in the security situation. So in 2013 we had a review done by COAG, but that was in a different security situation. We now have a heightened security situation, so we want that to be a key aspect of when this is now looked at. We've also recommended that the term supports and facilitates in the proposed amendments to the control order regimes be based on language in the existing criminal code. It is obviously these are key components of these new aspects of control orders that have been introduced, and we want to make sure that it is very clear that these supports and facilitates, to the extent possible, reflect the existing language in the existing criminal code. The committee also recommended that when the Counter-Terrorism legislation bill be amended to require that when seeking the Attorney-General's consent to request an interim control order, the Australian Federal Police must provide the Attorney-General with a statement of facts relating to why the order should be made and any known facts as to why it should not be made. Once again, here we're just making sure that there is proper transparency, and in particular that the AFP, in putting their case to the attorney, make sure that they take into account, okay, what are the facts relating as to why it should be made, and then so the attorney is fully aware of the known facts as to why it should not be made. Just highlighting once again the committee's desire to see transparency in this aspect. We also recommended that the bill be amended to require the Attorney-General's consent to an urgent interim control order, and that it be obtained within 8 hours of a request being made by a senior member of the AFP. Once again, we could understand why there needed to be a time frame here, and we thought that 8 hours was the appropriate time frame. Obviously, if the attorney is on a plane flying from one side of the nation to the other, then it would be very difficult for the AFP to be able to contact the attorney. You know, other than that, and it gives a bit of time either side to account from him landing, etc. But 8 hours we saw as the appropriate time frame here. The committee also recommended that proposed paragraphs 104.3d and 104.232b in the Counter-Terrorism Legislation Amendment Bill be amended to retain the current requirement that the AFP explain why each of the obligations, prohibitions and restrictions proposed in a draft control order should or should not be imposed on the person. So once again, we're looking for the AFP having to state their case very clearly and looking at the pros and cons. When it came to Schedule 2 of the bill, which are the proposed amendments to the Intelligence Services Act, the committee recommends that the EM to the counter-terrorism legislation will be amended to provide further information about how a class of Australian persons will be defined. The member for Kooyong touched on this point. We think it's very important that the public is fully aware of how this class of Australian persons will be defined, and we also then went on to say that it needs to be made clear that any Australian person included in a specified class of Australian persons agreed to by the Attorney-General must be involved in an activity or activities that pose a threat to security as defined by the ASIO Act of 1979. So once again, here we're looking so it's made very clear in the EM how this class of persons will be defined, because obviously we want the community to have confidence in the approach that we are taking with regards to expanding how these proposed amendments to Schedule 2 how they will be enacted upon. We also recommended that, subject to passage of the bill, that the Inspector-General of Intelligence and Security, the IGIS, provide close oversight of all ministerial authorisations given orally under this part of the bill, and also all agreements provided by the AG under the proposed amendments to paragraphs 9, 1A and B of the Intelligence Services Act, that she also provides close oversight there. Recommendation 9, we ask the bill be amended to require an agency head to notify the relevant responsible minister of an authorisation given by the agency head under proposed section 9B of the ISA within 8 hours. Once again, we thought that was a sensible time frame to enable the Attorney-General to be notified in this account. And then copies of the authorisation and other documents should then be provided to the Minister and the Inspector-General of Intelligence and Security as outlined in the proposed subjects 9B subsection 5 and 9B subsection 6 of the ISA Act 2001. We also said that the IGIS should be required to oversight within 30 days all emergency authorisations given by agency heads. So once again, an important check and balance in this aspect of the bill. And then the IGIS be required to notify the Parliamentary Joint Committee on Intelligence Security within 30 days of all emergency authorisations. So here we're not only is the IGIS acting as a check and balance, but the committee itself will now be playing a role in making sure that these emergency authorisations are used only in exceptional circumstances. Recommendation 12 that the committee recommends the Counter-Terrorism legislation bill be amended to require an agency head to notify the Attorney-General within 8 hours of an emergency authorisation given with the agreement of the Director-General of Security or without the agreement of either the AG or the Director-General of Security. Once again, just making sure proper scrutiny is in place. And recommendations 13, 14 and 15 once again enhance the authorisation, the oversight around the Schedule 2 of the bill. And if time permitted, I would go into a bit more detail on those recommendations, but as the clock is ticking, Mr Deputy Speaker, I'll have to leave that, but I would recommend to all members of the House to have a look at the recommendations, because they do provide the type of safeguards and oversight so that we can be confident and comfortable that our intelligence agencies will be acting in an appropriate manner and way, as they always do when it comes to keeping our nations safe. Can I thank all the members of the Parliamentary Joint Committee for the way and the manner they went about us looking at this bill. Can I thank the Secretariat for once again their very professional advice and manner in the way that they helped the committee in its consideration of this important legislation. These three pieces of legislation enhancing our national security have been complex. They have required a great amount of time being spent in looking at them by the committee, and committee members and the Secretariat have been incredibly professional and diligent in the way that they've gone about it. To suggest that this is some sort of club is a complete and utter nonsense. The committee's work has made this legislation better, and I think has improved the security and safety of our nation, which should always be the #1 consideration of government.
I thank the honourable member.